Hello there, my friends. I've got a great conversation with a constitutional law professor at Georgia State University. Our great friend, the legal eagle Eric Segall, joined me on Friday to talk about all the chaos that our cartoon villain ayatollahs on the Supreme Court have decided this week. And we caught up. It was really comprehensive, as it always is with Segall. A lot of context about the cases decided in the conversation, so I'm just going to not repeat myself. I can't do this without you. Patreon.com/Pete Dominic. It's the place to go to support the work. I put up, I think, 6 episodes or conversations at least this week, and I'll be putting up some great stuff next week. And of course, as always, support Eric Segall. Listen to his podcast, Supreme Myths, get his books, and let him know that you heard him here on the show. All right, that's it, huh? I wanted to get the intro done in under a minute, and I think I did it. It's the legal eagle, Eric Segall. Okay, well, it's Friday in June, and so it's time to talk to Eric Segall about the chaos that the Supreme Court is bringing, and he is joining me now, and in case you're not watching it, he is sitting in his home office with a sign that he made. It's a piece of paper. It's taped to his shirt. It says, "Not a court." Good day to you, sir.
Thank you. How are you, my friend?
People in the stand-up community are saying they can hear you scream across the country. Is that accurate?
Well, if there was ever a day to scream, this would be the one. I'm going to try to remain calm because my blood pressure and heart stuff, which is usually very good, is not so good today.
So where do you want to start on today's cases, decisions at the Supreme Court? The 6-3 decision, the Supreme Court severely narrowed a federal criminal law that makes it a felony to obstruct an official proceeding. That's one thing. But the more important case, and that's having to do with the Insurrection Act, you don't really want to talk about that. This law let me start over. In a 6-3 decision, the Supreme Court severely narrowed a federal criminal law that makes it a felony to obstruct an official proceeding. This law, which carried a maximum sentence of up to 20 years in prison, was a critical tool in the Department of Justice's effort to prosecute January 6 insurrectionists. As a result, we should expect that hundreds of defendants may see their sentences adjusted, J6ers that is. Worse, Donald Trump and his MAGA supporters are sure to claim vindication as this case is spun into a deep state conspiracy narrative. That's Mark Elias just talking about that. You don't want to talk about this one because you're not an expert on this.
Well, first of all, Mark is terrific. So if he says something, you can usually take it home. I'm not a criminal law professor. This is a Supreme Court interpretation of a criminal law statute on highly technical grounds. I do not feel qualified to discuss that, but I will say this. I am qualified to say, Pete, this is a continuing trend that far predates the Roberts Court of the Supreme Court of the United States, protecting white collar criminals, protecting, the type of crimes that they view, January 6th notwithstanding, as probably not as serious as other crimes. And this is why my understanding is no one went to jail. The 2008 financial meltdown, right? This is just more of that. I'm not saying it's not terrible. What I'm saying is it's not uniquely the Roberts Court.
Okay, that's important.
For a long time.
The second case that you do want to talk to about a lot more is that the Supreme Court struck down the so-called Chevron Doctrine, which had said that courts should defer to reasonable interpretations that they administer. And Mark Elias says about this was the top priority of those seeking to cripple the, quote, administrative state as a part of implementing the Dangerous Project 2025. And then he goes on just to add, meanwhile, we now know that the Trump immunity decision will now arrive on Monday morning. And so we can talk about what that, if anything, has to do with this. But I know you mostly wanted to talk about how important and consequential that decision was and how it probably, as Harry Lippman says, overruling Chevron will have a far broader effect on more people than any case from this court to date. Other cases they've done represent huge changes for some Americans, e.g. abortion, affirmative action. But this is utterly cross-cutting for society. Do you agree, starting there?
Yes, and he's 100% right. I don't know if it affects more the women who are affected by the abortion stuff. I'm not going to say this, but in terms of sheer numbers of people, yes, this is by far and away the most consequential going into the future decision probably of this term. Can we start at the beginning, Pete, on this?
You can start wherever you want to start, Professor. Just to make a note, he is still wearing the piece of paper that says not a court. Go ahead.
So we have 3,000 miles from coast to coast, Puerto Rico, Guam, and Alaska. And we have a Congress full of about 800 people, whatever the number is. I apologize. I don't know the exact number. And we have incredible problems in terms of climate, economy, military, foreign policy, safety, dealing with the internet in 1,000 different ways, and so on. Can Congress legislate with specificity how to resolve, for example, the relationship? Let's just take something I know nothing about. The relationship between airplane travel and climate change. I have no idea.
Yeah.
I can assure you the Congress has no idea. So what do? They say, as a general proposition, air pollution is bad. Can we all agree air pollution is bad? We think, we're not sure, that planes flying in the sky at 30,000 feet all over the world is contributing to this, but we're not sure.
Right.
So we're going to put a ban on fix air pollution. And then we're going to tell the President of the United States, research this, figure it out, and make some rules. If we don't like the rules, we being Congress, then we can come back in and overturn them. But we don't have the time to study everything that needs to be studied for this and 1,000 other highly technical issues. Now, this has been going on since 1788, basically. George Washington was given $1 million by the Congress and said, spend it, don't spend it, figure it out. We're a new country. We trust you. That's how it's always worked. And so eventually a unanimous Supreme Court, minus 3 people, but still a unanimous Supreme Court, including Justice Antonin Scalia, ruled that when Congress passes a law that's not clear, which, by the way, is most of Congress's laws, when Congress passes a law that is not clear, the executive branch agency interpreting it, this is their job. Do as well as you can, stay as close to that law as you can. And if you do so reasonably, that's fine. If you do so irrationally, then the judges are here to overturn it. But we're going to give you a big degree of deference because we don't know about air pollution in planes. We don't know about water pollution and mercury poisoning. We don't know about endangered species and so on and so forth.
Right.
A perfectly reasonable system and one that has been in this country since George Washington. That case was unanimous. So what has been happening since then, after the Reagan and Bush judiciary took hold, is they want to transfer power from agencies to judges. So the case today overturns that unanimous decision. Justice Kagan in dissent, seconded by my friend Mike Dorff, in his blog post just now on Dorff on Law, says all of our rules for overturning cases, when should we overturn cases? This was a major landmark case.
Right.
None of them justified overturning this case. So leaving aside what we do in the first instance, which, by the way, Chevron did exactly right, but leaving that aside, did we meet the standard for overturning a landmark case? Answer, no, we did not.
Just to be clear, 2 things I want to highlight or underscore and be clear about. What you're and everybody else is trying to tell us today is that this court has yet again taken an already decided case called Chevron, and they have overturned it. And overturned precedent is something, overturning a case like this is not something that the court has done very often, if at all, when there's a precedential case like this one, Chevron.
No. They do, and they have. But they overturned Roe. They overturned the biggest affirmative action case. They've overturned a lot. And the Warren Court overturned a ton of cases. That isn't the point, though. This was a unanimous opinion. Now, that's different. That's a little bit rarer. Overturning a unanimous opinion. What now? Chevron was a unanimous opinion. This court. Hold on. But it was 6-0, not 9-0. Three judges couldn't participate. So that doesn't matter. Future courts upheld it, future Supreme Courts. I don't want Pete, the court reverses itself a lot, so I don't want to take that position.
Okay, so but I wanted to clear that up. I want to know how important that was because I was confused. And the other one is just to underscore what you said is now, and everybody is saying they're giving power. They're taking the power away from my friends who are ecologists and biologists at the Fish and Wildlife Agency, working with those endangered species on federal wildlife refuges. They're taking their expertise to keep the air and water and each one of those critters safe, and they're giving it to some schmuck who's a federal judge.
Yes, and here's the problem. The Supreme Court has actually done a reasonable job this calendar year of overturning the Fifth Circuit when the Fifth Circuit has gone crazy. They have. They've done a reasonable job on that. I believe they've overturned the Fifth Circuit at an unprecedented rate. So kudos to them. But they don't have time to review all of the craziness that's about to happen. So let me put it in real terms, not law professor terms. 1 hour ago, I had lunch with a friend of mine, a University of Virginia graduate, a fantastic lawyer, commercial lawyer. His specialty is covenants not to compete. Don't worry about that. But he does real law for real people in real courtrooms. And he said to me, I was asked this morning by my partners to write a memo. What does the reversal of Chevron mean for us? And so he had lunch with me to ask me, Eric, what does the reversal of Chevron mean for us? And this is what we both agreed on. He agreed with everything. We discussed it jointly. From now on, Pete, the stakes of who is sitting on the lower courts has now been ratcheted up 150%.
Right. So the lower court, you can expect judges to be appointed by Donald Trump that will be an actual lump of coal. Or a bullet. He will appoint a judge who's a bullet.
No, that's not what I meant. It is true that Trump appointed a bunch of crazy judges in Texas and other places that we have to worry about. But let's say we're a reasonable Republican. Let's say we're Mitt Romney, or if there are any Mitt Romneys left or whatever. Let's say we're Republican, we're conservative, but we're not Trump. And we have reasonable disagreements over policy issues with liberals. Reasonable disagreements, which are fair, right? In the past, you would lobby Congress to get what you wanted. And it was really important that you got what you wanted. You really can't lobby executive branch officials. How does that even work? You take out a civil servant for breakfast. I mean, it doesn't work that way. Let me finish. So now all of those hearings in Congress on lower court judges that almost everybody ignored for good reason, they're now incredibly important because a liberal judge, a good liberal judge, now gets to say, well, if I think the Trump administration's rule on whatever, X, isn't great, it's not irrational, it's not stupid, but it's not great, and I think it misinterprets the law by 1%, then I'm going to reverse it. And that's a crazy, in the past they had to say, is it unreasonable? Is it irrational? Is it obviously wrong? Now they're just saying, do I disagree 50-50? Well, that is a tremendous amount of power. And it makes the stakes of the lower courts much higher. And the last thing we needed in fucking America is to make the judiciary stronger. And that's what this does.
Why am I wrong about the fact that now they will appoint judges who are in the pocket of certain industries?
They will. You're right about that. Okay. But both sides will do it, Pete. My point is both sides will.
Well, yes, but when liberals do it, they're going to be on the side of, say, like the environment or labor rights or women's reproductive rights. And those causes and cases are so much more nebulous than, say, coal.
Right. But Pete,
as a source of energy or guns or some such tangible rights and dangers.
Let's look at this from a realistic perspective. The laws involving Title IX, if you're an educational institution and you receive federal funds, which is all colleges and universities, then you have to follow a set of rules, one of which is you can't discriminate on the basis of sex. So the question is, does that apply under Title IX to sexual orientation? And the law is unclear. There's no getting around the impreciseness of the law. Pete, I don't want anybody deciding that issue except Congress won't decide that issue because of political reasons and because it's too hard. So now we have to decide what's next. And what's next should be experts at the Department of Education who spend their entire lives studying, implementing, amending the regulations, and passing regulations to implement that law, unless they do something really stupid, they should be allowed to do it. That was the law before today. Now the law is, if there's a reasonable disagreement between judge and expert, the judge wins. And that's an insane way to run a country. We're letting Judge X from Idaho decide huge public policy questions. One last thing. Those agency officials who make these decisions are accountable to the President of the United States, who is accountable to the American people. And even in his second term, his party is accountable to the American people. Judge Gubernaber in Idaho and Justice John Roberts of the Supreme Court are accountable to no one. No one. There is no accountability. Zero. None. The empty set. Why would we transfer power to people with zero accountability to anybody?
Mark Joseph Stern, writing in Slate, says, in Chevron, the court unanimously announced an important principle of law that can govern the nation until Friday. When a federal statute is ambiguous, courts should defer to an agency's reasonable interpretation of it. Why? Congress delegates countless important calls to agencies, directing the EPA, for example, to limit harmful benzene emissions, rather than providing the precise formula to determine what that level of benzene emissions is harmful to humans. Congress writes statutes broadly because it expects these agencies to respond to new facts and adjust their enforcement accordingly. Guess that's going to change.
Yes, Mark said that beautifully. And I want to say something else, Pete. This is just the first shoe to drop. I've said this before on your podcast. I appreciate for my look at me, Louis moment, but I'm going to do it anyway. In November of 2016, I wrote a piece that Newsweek published that asked, what will a future Trump Supreme Court look like? 2016, right after the election. And I said, obviously, it depends on the number of picks. But assuming he gets 2 or 3 choices, this is what it will look like. And I said, we all know he doesn't care about abortion. That is simply a way to get elected. What he cares about, and the only thing he cares about, is deregulation of the economy. He's going to start with agencies. That's how the court's going to start to do this. But eventually, Pete, what they're going to rule, this Supreme Court, if it stays the same, is even when Congress acts directly, right? So if the agencies can't do it, then Congress should do more, theoretically. But the court's going to limit Congress's power to, and under the Commerce Clause. What this is all about is environmental. When I first met you, when I first started listening to you in 2008 or 9, one of the things you harped on that impressed me so much, why I liked you so much from the start, was, and the whole theme of your show on XM Radio, was we need experts. Yeah. We need experts to talk about the issues. Yes. We need experts to resolve the issues. Lower federal court judges are not experts on any of these things. Right. The agency officials are. And if we don't like what the agency officials do, there are 2 ways to solve it. Either vote the president out of office they're responsible to, or punish the political party they belong to, or get Congress to pass a new law, both of which are doable, but certainly very hard, but not as hard as trying to convince a life-tenured judge who's accountable to no one to do the right thing.
Let me ask you one more on Chevron by way of 2 more quotes. Josh Marshall, Talking Points Memo. I always love his political analysis. Very smart guy. He says, Chevron decision is technical. It'll get very little coverage because it has to do with issues of deference and regulation and snooze, put me to sleep. But in terms of effect on your life, water you drink, how the whole country is run, this is likely far and away the biggest decision. Alyssa Rubin adds, while the media is consumed with last night's debate, this decision will shape how American government functions for decades, no matter who wins in November. What would you add to that? Or what would you say as a last comment about this case before we get to the homeless issue?
I agree with all of that. I cannot emphasize how much damage this decision is going to do. Pete, it's not just, if this had been the first decision, if Chevron, back in whenever it was, 25 years ago, 30 years ago, if it had come out this way, that would have been terrible. It's not as terrible as this, because this is saying to judges, we got it wrong all these years. Do more. It's like a license. Do more. It's the worst of all worlds, Pete. It is just, and here's the other thing. that you won't hear probably much in the media. Whether it's text, history, or precedent, none of those things cut in favor of this decision, and all three cut strongly against it. As I said, we've had agency discretion since George Washington. These people who claim everything is about history, where are they today?
Right. So let's move on. This is Rachel Cohen. She writes at Vox, and she covers social policy, focuses on housing as one of her issues, and homelessness. And she writes about Grants Pass v. Johnson, the Supreme Court case that also was decided today. They issued that long-awaited ruling, the most significant legal challenge to the rights of homeless people in decades. In a 6-3 decision, she writes, written by Justice Neil Gorsuch, your friend, Segall, the Supreme Court ruled that cities enforcing anti-camping bans, even if homeless people have no other place to go, does not violate the Eighth Amendment's prohibition on cruel and unusual punishment. Gorsuch was joined by the rest of the court's conservatives, including Chief Justice John Roberts, and she goes on to write, just in real life, Friday's ruling has huge implications for cities and people experiencing homelessness nationwide. Leaders from dozens of cities and states, both liberal and conservative, have been hoping the U.S. Supreme Court would overturn this case, which they claim were incorrectly decided and left governments hamstrung and incapable of safely managing their communities. And that's where I'll stop reading there.
So in a world where I should preface this by saying, Pete, the contours of the Eighth Amendment's cruel and unusual punishment clause, I will say I know something more than the average Joe about it. I'm not claiming to be the world's biggest expert on it. So I'm going to make my point this way. In a world where the Supreme Court was a real court, hence this is why I'm wearing this today. In a world where the Supreme Court was a real court and followed precedent and followed text and followed history, this case might be legally correct in a very technical sense. But that's not our country, and that's not our world. And the Supreme Court has never done that. So in a world where the Supreme Court does things just because it wants to, this case is it's really bad in terms of, I don't know how to say this. If a city has people who are homeless, unhoused people, and they don't build a place for those unhoused people to go, which is this case, and to then punish them for being unhoused just seems impossibly stupid and wrong and immoral to me.
Right.
It's one thing if you say, you have that shelter over there, please go in that shelter. And the person says, no, I'm going to sleep on the street. We can have a conversation. But that wasn't this case. There wasn't that option.
Well,
it's terrible.
I look at this case, I'm no con law scholar or social policy expert, but I look at it from a more theological standpoint, of course, which I am an expert in theology. And I think, what would Jesus do?
He would not put them in jail. That's what Jesus.
No, I think he would be a slumlord. I kid, Jesus. I kid. Yeah. So let me just you have any more on that?
No.
Before you go, yesterday, the Supreme Court decided a very important case regarding abortions in medical emergencies. The decision reinstated a lower court ruling that temporarily allows hospitals in the state of Idaho to perform emergency abortions to protect the life of the mother and the health of the mother. What do you want to say about that case, that decision?
I want to say something about that case and the other abortion case this term, where the court found no standing in the abortion pill case. Pete, this is not rocket scientist here. If anyone who's listening to this show, rocket science, if anyone listening to this podcast is not yet convinced the court isn't a court, this will be as good proof as you ever find. They did everything in their power to avoid deciding an abortion case this term. The first case they got rid of for lack of standing. The second case they got rid of on a purely jurisdictional technical matter. They will eventually issue negative rulings for abortion rights in both cases. But they didn't want to do it before the election. If you don't think that's what they thought, you, not Pete Dominic, you listening to this are not paying attention. And they did both cases. And the one in Idaho is really bad, Pete, for this reason. The other one, at least, the status quo was good for women. So at least we could say that. But this one, Idaho's irrelevant. I don't know how many women are in Idaho having abortions. I don't mean irrelevant. It's not a national catastrophe. Where the catastrophe is Texas. Because as people know, this issue is much bigger in Texas, where Texas law, has all these requirements. And the court could have taken care of Texas in this case. They could have said, listen, if you're in an emergency room and you take Medicare money, if you don't take Medicare money, it's up to you. But if you take Medicare money and the choice is between a dying fetus and the woman's health, you always privilege the woman's health. That ruling would have applied to Texas, and that would have saved a lot of lives. Because they delayed it, Texas is now free to do whatever it wants. That's the real problem. But most of all, the immunity, this is my last comment.
Yeah.
The immunity case taken with the January 6th case. January 6th disqualification, super fast tracked, not disqualified. Immunity, last day of the term, and even going into July, which is not that typical. Abortion, get rid of both abortion cases. What they're doing is everything imaginable to help the Republican Party. And if that's not clear to people, I don't know how to make it more clear. They punted these abortion cases because of politics, period. Now, it turns out the standing analysis is probably correct in the first abortion case, but so what?
And they delayed immunity, or took immunity, as they even took a look at it, even though it was decided unanimously by a lower court. The fact that they took it and then delayed it was also politics, right? So finally, what's left?
Immunity is left, and then there's three. The two that I'm watching are the immunity case, and then Pete, I'm starting to get a little nervous about Monday. I never was before, but so we have this case where both Florida and Texas are trying to regulate Facebook and Twitter and Instagram and say you're not allowed to kick people off. Everyone seems to think there's no way the court is going. So the 11th Circuit said that state law was unconstitutional and struck it down. The 5th Circuit, of course, in Texas said it was constitutional. Everybody thinks they're going to say that the 11th Circuit was right, the 5th Circuit was wrong, these laws are unconstitutional. Because the government is not allowed to tell private companies what they can and cannot say and what they can and cannot publish. They just can't. It's like elementary First Amendment stuff. I'm starting to get a little worried now. Like, I'm wondering what's going to happen with that case.
Just to be clear, it's not just Facebook and Instagram. This is a case that would allow states to affect how Facebook, TikTok, Twitter, YouTube, and all other social media platforms regulate content posted by their users. States regulating the content that I post. Yes.
And again, if I had to bet right now, I'd say, of course, the court is not going to do that. I mean, the court's not going to allow states to do that, especially this court, which is so First Amendment friendly that it strikes down everything under the First Amendment, even things that are on speech. So I'm still predicting that. But I'm starting to get a little nervous. And maybe,
technically they can do this. Some states prevent you from accessing pornography if you haven't gotten permissions, et cetera. Like, there's technical ways to prevent you from accessing or posting, et cetera, on different platforms.
But obscenity is not pornography, but obscenity is different. Obscenity is not protected speech. So you can be thrown in jail for obscenity, in theory. Obscenity is outside the First Amendment. The speech, and there's no question that no matter what happens in this case, Facebook and Twitter can always kick off obscenity, kick off threats.
They can do it, but this is about the state deciding.
Well, that's complicated.
Oh, I don't know. That wasn't an assertion. I'm sorry that didn't end in a question mark.
Yeah, that's complicated. Let me just say this. Can we simplify it to Facebook and Twitter, because it's too hard to. Facebook and Twitter are
because they're the ones that you old.
Okay, and Instagram. Facebook, Twitter, and Instagram are private. Well, Facebook owns Instagram, so whatever. Those companies are private companies like the New York Times, like Exxon. It is Hornbook First Amendment law that the state of Texas is not allowed to say to Exxon, when you distribute your monthly newsletter, to your shareholders, you can't say this, you have to say that, you have to say this, unless it's fraudulent speech.
Yep.
That's called censorship. We don't allow that in America. The Fifth Circuit said we can censor, we meaning the state of Texas, can absolutely censor Facebook and Twitter because they're more like trains, planes, and automobiles than public carriers, than they're like the New York Times or Fox News. That's absurd. That is stupid. They're not a common carrier. Facebook engages and deals in speech. Its core business is speech. We can't have Texas telling Facebook, you have to let this speech, but you can't reject that speech unless, Pete, going back to obscenity, if the speech is outside the protection of the First Amendment, then yes, Texas can say to Facebook, no obscenity for you. But it can't say no political speech for you. That would be insane.
What else? Insane. We done for today?
I think we're done for the day, Pete. I'll see you Monday.
We'll see you Monday back here for immunity. I hope that your immunity stays strong. We're worried about you catching cold because I
am close to giving up. I am close to giving up.
No. We don't talk that way here.
Sorry, I am.
No, you're wearing. No, if you were close to giving up, you wouldn't be wearing a sign the entire.
No, it's my final bow. This is my final bow, right?
Stop it. We won't have any of it. We love you and we thank you, and we will talk to you next week.
Thank you, my friend.
All right, there he goes, Eric Segall, everybody. I hope you appreciated it, and I hope that you let him know how much you appreciate him joining us. You bumblebees here at the end, thank you so much for your support. Can't do it without you. I love you. I hope you're having a great weekend. Finding peace. Remember, you can always turn it all off. Go outside. Enjoy yourself. Get some air. Get some space. Be well. I'll talk to you tomorrow.
For the burning trees, you got to stand up. Hey, you've been sitting so long, you got the creaky knees, you got to stand up. Stand up. I think you're driving wheels with leaking grease. Boy, you better stand up. Stand up. Well, there's a whole lot more of us who know what's right. They'll keep right on ignoring us if we keep things right. We got to open up the window to let in some light. You gotta stand up. That's right. We got to rise up. You got to stand up. You gotta stare the devil straight in the eye. We got to let him know it's his turn to go. See it clear when all you hear is a lie. Don't get up off of your butt, get down off of your fence. Even if it ain't a very friendly audience, well, they'll begin to listen when you start making sense. And you stand up, stand up. No need to point your rifle to defend your town. Just stand up, stand up. You know they can't deny you what you're laying down. Boy, you better stand up, stand up. Show your face of every color, yellow, black, red, and brown. She's the place where every lost child will finally be found. There's only one thing to do before we stand our ground, and that's stand up, stand up. Well, the founding fathers saw a land for all. They had to stand up, they had to stand up. They had a keen imagination for a crystal ball, drawing all the plans of a stand up. But all they had to go on was the time they were in, with other causes for laws, and since they weren't even sin, they knew that change was gonna come before the change could begin. They had to stand up. All right, they had to stand up. We got to stand up. We got to look the devil square in the eye. We gotta let him know it's his time to go, and make it clear when all we hear is a lie. Why you lying awake wondering where the money all went? It'll be the cost of freedom that'll go unspent. You can see him flee the scene of that experiment if you stand up. Alright, we got to speak up, we got to reach up, and raise your voice in every way you know how. Don't be toes up, you got to show up. Ain't no better time to do it but now. No need to pledge allegiance to no wanton tribe. Rise up, show obedience to the voice inside, and listen well and it'll tell you not to run and hide. It says stand up.